welcome everybody to the Mills and Reeve Family Law Matters webinar. This webinar today is a comparative discussion of cohabitation law, and it's set to go on until 10 a.m, although we were just talking and thinking that we might finish a bit early. Some of that depends on any questions and answers that you might have, which we are asking. If you do have any questions, please put them in the Q&A and I'll pick them up as we go along. This is being recorded and the recording will be sent out after the webinar. You'll also receive a feedback form which we would ask you to complete. That's really helpful to us in terms of the future webinars that we're going to run, and there will be other webinars in this series. So first of all, just to welcome my three guests today, Jeff Wilson, who's from Australia, Karen O'Leary, who's from Ireland, and Jen, who's from M&R in Norwich. And I'll just introduce each of you individually. So first of all, Jeff Wilson is a partner at Hopgood Gammon Lawyers, and he's providing the Australian perspective. He is a priority market leader and has a pro bono practice as well as his family law practice. He's a fellow of the International Academy of Family Lawyers, the immediate past president of the Asia Pacific chapter, and past parliamentarian, and he's current co-chair of its dispute resolution committee. He's recognised as a preeminent family and divorce lawyer by Doyle's Guide to Leading Australian Family Lawyers, and has been a leading lawyer for many years. Now, I asked everyone to provide a fun fact, and I think you'll see that Jeff is actually in his cellar. In fact, whenever we have any meetings with Jeff, he's in his cellar. I do believe he goes to work, however, to get all of the credentials I've just discussed. But he says his fun fact is that his cellar is bereft of English wines, and that's not just a subtle request, although we'll see what we can do. Thank you, Jeff. And then over to Karen O'Leary, who's the senior partner, head of family and child law practice at Caldwell and Robinson Solicitors. She'll be giving the Irish perspective. She's got extensive experience on all issues that may rise upon the breakdown of relationship and family law, has specialist expertise, covers both private and public law in multiple jurisdictions. Karen is tri-jurisdictionally qualified in Ireland, Northern Ireland and England and Wales, and is regularly consulted by government and state agencies on legal matters from other jurisdictions. Karen is a fellow of the International Academy of Family Lawyers, member of the International Committee of Resolutions, a chartered family arbitrator, mediator and a collaborative lawyer, ranked Band 1 in Chambers. And her interesting fact is that all year round, she's a sea swimmer and she doesn't believe in wetsuits. Wow. Okay. And then on to Jennifer Curtis, otherwise known as Jen, a principal associate at Mills and Reeves in the Norwich office, recently returned both to Norwich and to M&R, having spent the last 10 years as a boutique family law firm in Cheshire. She advises clients in all aspects of family and has a particular interest in cases with an international perspective, something which has grown from her degree in European law and studies in France as part of her degree. Jen hosts the Mills and Reeve Explaining Family Law podcast, available from the Mills and Reeve website or through Spotify and Apple Podcasts. And the two most recent episodes deal with the rights of unmarried couples. And I would urge our listeners actually to listen to that podcast. It's absolutely excellent. And there's been a number of episodes, so get on and listen to that. So Jen's interesting fact is growing up, she, in her free time, spent doing all things musical, including playing the bassoon. So what an interesting panel we've got. So today, as I've indicated, we're going to be talking about the intricate tapestry of cohabitation law and its reform across three distinct legal landscapes: England, Ireland and Australia. As societal norms continue to evolve and shift away from traditional marriage, we witness a significant rise in cohabitation, with England seeing a 144% increase in cohabiting couples from 1996 to 2021. This trend is mirrored in Australia, where 56% of adults are married or committed, leaving a substantial portion cohabiting. Ireland too reflects this shift, with a notable increase in marriages in 2021 following the pandemic, yet the underlying trend towards cohabitation remains evident. Today, we will compare the legal framework governing unmarried couples, particularly those with children, and explore how these laws adapt or fail to adapt in the case of our jurisdiction, England. And our comparative discussion will explore the nuances of each jurisdiction, explaining how legislative reforms have shaped the current state of cohabitation law. We will also consider the potential pathways for future legal advancements, drawing insights from experiences from all of the countries who are listed here. So join us now as we navigate the complexities of these laws, understand the proposals for reform, and consider the impact on the lives of countless families and children who choose to live together outside the bounds of traditional marriage in these regions. So starting off, I've already explained some of the statistics, but I wondered if you could tell me the number of married couples versus cohabiting couples and the percentage of children born to unmarried couples. Jen, I've started off saying some stats in England, but if you could follow up with that, that would be great.
Of course, Suzanne, thank you. So the way in which we express our statistic is the proportion of people who live in a couple that are cohabiting as opposed to married. And the data comes from our census, which is undertaken every 10 years. So as at 2011, we had 20.6% of couples cohabiting, which had increased by 2021 to 24.3%. And what was really picked up in those statistics was that the increase in cohabiting couples was across all age groups, except for the over 85s. So it's not just a trend that's affecting one particular group, it's across society. It did flag that the 25 to 29-year-old age group was the biggest increase, going up to 71.6% of those couples being in a cohabiting relationship rather than married. In terms of children born, we've seen, again, a massive shift there. And I think what comes to light is the fact that as of 2021, we tipped that balance into 51.3% of children being born to unmarried couples. And I think that move from just slightly under 50% in the years before to tipping that 50% balance has been a real significant statistic.
Thanks very much. And what's the situation in Ireland, Karen?
So we still have quite a traditional approach, I suppose, in terms of family units. It is changing. The drilling down from the census has clearly demonstrated a dramatic shift, I would say, and I think the next one will show an even greater shift. But 36% of the population are married. Only 1.8% are cohabiting without children, and 1.6% with children. Now, that would appear to suggest it's a very minimal number, but when you actually look at the previous census, which was in 2016, there has been an increase of just under 20% of couples cohabiting without children and a 12.8% increase on cohabiting couples with children. So I think it follows the trend. It's a little slower, but we've had dramatic changes in terms of our protection of cohabiting couples. So I anticipate that trend will increase significantly over 2020 to 2030.
Thanks very much. So setting the scene, what about you, Jeff?
Suzanne, similarly, in Australia, as say England and Wales, not so much with Ireland, our last census was in 2021, and it reported there were 8.7 million people who were married, including 24,000 who are in same-sex marriages, and there were 2.168 people in a de facto or cohabiting couple. So roughly about 20% of couples are in a de facto relationship in Australia. And again, as you had introduced, back in 1986, it was only 6% who were cohabiting couples. So there is that upward trend. Our census and statistics don't break down the percentage of children born to an unmarried couples. The statistics go so far to say there's 43.7% couples with children. As to the breakdown between marriage and de facto, we don't get that detail. 38.8% of couples with no children. So that's where we stand in Australia at the moment.
Thanks very much. And so if we just now have a dive into the law, what's the current law in your country regarding cohabiting couples on a relationship breakdown, including in relation to pensions? And when did the law change? I'm coming to Jeff first, because I have to say,
Sure.
I think you're much more advanced than we are here, and there's a lot to learn from you. So if we hear from Australia first, that'd be great.
Well, Suzanne, essentially, under Australian law, there's no distinction between whether you're married or in a de facto relationship. Essentially, if you're in either relationship, you're entitled to the same rights. So the Family Law Act, which is our Commonwealth legislation governing families, it provides for de facto relationship financial matters, and in particular, property settlement, which is determined exactly the same way as parties who are married. Excuse me. Essentially, the law is based on an assessment of contributions made by the de facto couples with adjustments for future disparity, things like provision for the primary care of children and earnings disparities. Spousal maintenance is available for couples in de facto relationship, and our super splitting regime, which forms part of your property settlement, is available to de facto couples. Now, the Commonwealth legislation commenced on the 1st of March 2009, but that wasn't really the starting point, because I don't want to bore all the listeners in relation to the constitutional issues, but going back to our constitution, the Commonwealth only had power over marriages. So it was the state governments and territories that had powers over cohabitants, de facto relationships. And from about 1984 onwards, the various states and territories started introducing legislation. Prior to that, our laws were very similar to the way you determine matters today, based on common law and equity, with particularly an emphasis on constructive trusts, etc. 1984 onwards, we saw the states introduce legislation which had varying effects, but very akin to the Family Law Act. Most of them provided for property settlement and for agreements. A lot of them didn't provide for spousal maintenance, and certainly not for superannuation. Then all the states got together and referred their powers to the Commonwealth, and hence we've arrived today where we've got a full suite of remedies for our de facto couples, which are essentially the same as if you were married.
Wow, so basically 40 years of being treated almost similarly since 1984. That's incredible. And Karen, what about Ireland?
Yes, we're not as progressive. So there was previously very little meaningful protection given to cohabiting couples in the 20th century. Early 2000s, the Law Reform Commission published a report. And I suppose what is critical in this is it recognised the requirement for the addition to the law, and this is the important bit, to protect vulnerable family members on relationship breakdown. And I stress that, and you will see why, because of the criteria that needs to be established before you can bring a claim. Following those recommendations from the Commission, a statutory redress scheme was introduced which allowed claimants to simultaneously pursue claims under the civil partnership and certain rights and obligations of cohabitants, and that is the Act of 2010. And also they have the right simultaneously to claim in equity. So it's interesting to see that the two are in harmony in terms of the law. But as I say, you need to be a qualified cohabitant. And there are certain circumstances, and I'll deal with those perhaps a little bit later, but there are particular elements that need to be fulfilled in order to bring an application. And that relates to the duration of the relationship, the basis on which the couple live together, the degree of financial dependence of either adult on the other, and any agreement in respect of their finances, the degree and nature of any financial arrangements between the adults relating to property, whether there are dependent children, and whether one of the adults care for and supports the children of the other, and the degree to which the adults present present themselves as a couple. So if you are considered qualified and you are financially dependent on the other, then you are entitled to bring a number of limited claims. And these relate to property adjustment orders, compensatory maintenance orders, pension adjustment orders, and other orders for provision from the estate of a deceased cohabitant. So the three things you need to have established is that the parties have lived together for a continuous period of 5 years, or if they have a child, 2 years. They have been in an intimate and committed relationship, and one is financially dependent on the other. So quite different from the Australian scheme.
Yes, almost like a hybrid scheme. And I suppose now England really lagging behind, Jen. We have here the myth of the common law wife, and I think you're going to explain to us why it's a myth. So if you can tell us the position in England, that'd be great.
Of course, yes. Unfortunately, we don't have one clear piece of legislation that we can point to that says, here are your rights to cohabiting couples. Instead, what we're stuck with is trying to jigsaw different pieces of legislation together. And we're probably most used to relying on the provisions of the Trusts of Land and Appointment of Trustees Act, which, given the length of the title, we abbreviate to TOLATA. Now, England has this wonderful concept of legal ownership of property, but also acknowledging that there might be a beneficial interest, which is different to that. So this sort of brings into this interplay about how do we work out what property law rights are, and how do we actually resolve those on separation. And really, it's evolved out of case law, with the judges sort of stepping in to bring into play concepts of resulting trusts, constructive trusts, proprietary estoppel. And those are all principles which in different ways look backwards over the relationship, looking at contributions, whether that's cash contributions to property or other tangible contributions, the party's intentions, and the way in which one party may have relied to the detriment on what the other person said or did to suggest they had an interest. And so what we end up with is a very fact-specific arrangement. People can't predict necessarily at the beginning of the relationship what would happen to them if it comes to an end. And parties are sometimes having to go back over 20, 30 years, what was discussed around the dining table when they bought the property. So there's a real gap there in terms of parties being able to understand what rights they have. I think we're getting there with dispelling the myth of common law marriage. I think that was abolished in 17 something or other. But actually what rights do people have is much harder to explain and convey. I think the other difference that we have in England is that any court case that is used to determine the rights of a cohabiting couple is not dealt with in the family court. So in the family court, we're very used to the judges having discretion, to use of the word fairness and concepts like that. But the procedural rules which apply for a cohabiting couple are very different. There's strict civil procedure rules that apply. And one of the key differences is that if you are taking a civil claim to the court as a cohabitant, you've got risks about costs. So we have in the family court, usual starting point is that each party pays their own. But for a cohabiting couple, you've got the bigger risk that if you're the unsuccessful person, you've potentially got to pay the other person's costs. And I think that can be a real deterrent in someone who's uncertain about their rights. Do they actually want to take that leap of faith and ask a judge to rule on their provisions?
Yeah, I think it's fair to say that it's both uncertain and potentially costly. And so that's tricky for people when they're considering at the end of their cohabitational relationship. I think we might have some good news, however, in relation to children. So if you're a cohabitee with children, I imagine the situation is different in most jurisdictions. Certainly it is in England. So if you can start this time, Jen, that'd be great.
Yes, I must admit that when someone in a cohabiting relationship comes to me and they have got children, I do express some relief that they've potentially got some slightly more codified rights. And those come from Schedule 1 of the Children Act 1989, which gives the court the power to make financial provision for a couple's children. Now, again, that legislation doesn't go as far as rights of a married couple, but it does mean that one parent can seek financial support from the other. That's both in terms of maintenance. Most people will have heard of the Child Maintenance Service, which is our government organisation who deals with the calculation of child maintenance, and they can also step in to seek payment from the paying parent if they default on those payments. There's also provision under the Children Act for provision for capital, whether that's a property, whether that's provision of lump sums. But it's really important to remember that when it comes to capital provision, it is for the benefit of the children. So very rarely would you find a situation where a parent is given a property outright to be theirs and theirs independently. Often it's the case that the property is either settled for the benefit of the children or that it reverts back to the parent who's provided that property when the children perhaps reach 18 or increasingly a little bit older. Lump sums can be sought for a number of different things. There's no exhaustive list. But some relevant examples might be medical treatment, refurbishment to a property, purchase of a car. And to some degree, the use of these Schedule 1 claims, as they're called, has evolved to offer a little bit of protection when it comes to legal fees. So if you are the financially weaker parent who is trying to seek provision for your children, the court does now have the power to make an award for legal fees to help you to fund your case to assert those rights for your children.
Yeah, and Jennifer, the situation is particularly stark. For example, if your children are above 18 and your relationship breaks down, say when you're in your 50s, and then you're in a really difficult situation because by then the house may have reverted to the father and you're stuck without a home. So they're really tricky situations, I think, even if you have had children. And I'm just wondering what that situation then is in Ireland, Karen, if there are children.
So the redress scheme, in essence, doesn't apply. You go back to looking at the 1964 Guardianship of Infants Act as amended, and in essence, one of the parents can bring an application for access, custody, a maintenance order, or a lump sum. Now, interestingly, whilst the mother is automatically gets sole custody upon the birth of a child of a cohabiting couple, the father does not, and it can either be done by way of agreement or court order. I suppose the biggest difference between England and Wales and Ireland is the provision of maintenance. It is not done by statutory scheme. It is either done by agreement or through the courts, and it continues until the age of 23 or ceasing third level education. So it's quite significant, and it can either be paid to the parent with primary care, depending on the terms of the order, or directly to the child. So that is probably the most significant difference between the two jurisdictions.
And it's probably reflective of the current situation with, people not being able to afford, children not being able to afford to move out of homes, etc. And perhaps, being financially dependent for longer. So perhaps that's something we in England need to pick up on. I mean, that's an interesting point, I think. Yeah.
Yeah, and I think it's extremely difficult for 18-year-olds to bring applications against their parents. Now, there is provision within our legislation to do that, but that would be highly unusual. It would generally be in place, and it would remain in place until the end of territory education. They have to be in full-time education,
right,
to receive the maintenance.
Thank you. That's really interesting. And Jeff, what about Australia?
Suzanne, of course, the Family Law Act applies to all, whether they're children or not. What I didn't mention last time around were there is a difference between de factos and the treatment of marriages in the sense of some jurisdictional limits or gateways, and I'll talk a little bit about those a bit later. But there's one in particular to financial matters, and in both property settlement and maintenance. The requirements to get to the starting line are essentially you've either been in a relationship for a total of 2 years, or if you have children, then there's no time limits at all. So there's one impact, and the other fallback is the substantial contributions are made by one party to the other party's property. In terms of the property settlement and the maintenance regimes, as I say, they mirror the marriage regime, and particularly when we're looking at property settlement, I was talking about the two aspects of contribution and adjustment factors. And I'll read the relevant part of the legislation just to give you an idea. When assessing contributions, the relevant provision is Section 90 SM4, which says, in considering what order, if any, should be made under this section in property settlement proceedings, the court must take into account. And then in subsection C, it says, the contribution made by a party to the de facto relationship to the welfare of the family constituted by the parties to the de facto relationship and any children of the de facto relationship, including any contribution made in the capacity of homemaker or parent. So it's particularly recognised in that regard and taken into account. And then the next part of the exercise, the adjustment factors, and the relevant provision is Section 90 SF3, and it says the matters to be taken into account are, and these include in subsection C, whether either party has the care or control of a child of the de facto relationship who has not attained the age of 18 years. D, commitments of each of the parties that are necessary to enable the party to support, and one of the subheadings is a child or another person that the party has a duty to maintain. Subparagraph L says the need to protect a party who wishes to continue that party's role as a parent. And then Q, any child support under the Child Support Assessment Act that a party to the subject de facto relationship has provided is to provide or might be liable to provide in the future for a child of the subject de facto relationship. And then following on both Jan and Karen's discussion about maintenance, or particularly child-related maintenance, our child support legislation specifically applies to children under de facto relationships, in fact, to any children. And for over 18, the Family Law Act provides for adult child maintenance, particularly to assist in terms of education costs or if there are special needs. So that, in a sense, is where the issue of children intersects for de facto relationships.
Thanks very much. So it seems so much clearer than the sort of piecemeal legislation that we have. So thank you very much for that. So if I look at that, I'd like to just explore, if we can, the benefits as you see them of your jurisdiction. And I think since so far, Jeff, you're the clear leader in terms of your law. You're at top of the leaderboard. I'm just wondering if you can start off by explaining what you think the benefits are of your regime.
Okay. Well, and I'll talk about in just a general sense, there's a body of authority now that's more certain in terms of outcomes as against common law and equitable remedies that were problematic, disparate and lacking any cogent or reliable precedent, which could provide certainty as to an outcome for de facto spouses seeking a property division. We have one specialist family court, as against in the past having to navigate two courts. We had the family court for parenting issues, because one thing I didn't mention was the states all referred their powers over ex-nuptial children of de facto relationships to the Commonwealth a lot earlier than they did the financial matters. So we had parenting matters being dealt with in the family court in the Commonwealth jurisdiction, whereas financial issues were being dealt with in the state courts. So one specialist court that's better resourced to deal with all the issues in respect to de facto relationship breakdown. We have also a widespread understanding there's no difference under Australian law upon the breakdown of a marriage or a de facto relationship. The real difference and difficulty lies in proving the existence, commencement and end of the de facto relationship, which I'll come to. So the benefits for de facto spouses are that they have essentially equal footing with their marital compatriots. They're all entitled to property settlement, which includes super splitting, third-party orders, injunctions, spousal maintenance. They can enter into financial agreements as marital couples can, so they're afforded that private autonomy. People who want to opt out of the system, if they feel that, and one of the issues for many, and I understand it's something you're grappling with in England and Wales, is this issue. I'm consciously a couple who's not married. Why should I be treated the same? Why should I be swept up in that vortex? If you want to opt out of the Family Law Act, enter into a financial agreement. It's available to all of our de facto couples. And essentially, from a legal practitioner's perspective, it's really just business as usual for us. And our clients are accepting of the laws and the reality. There's been no real pushback at all. And maybe, and I've said this in other places, maybe our clients were conditioned a long time ago with the states having brought in this legislation. So it wasn't something that was overnight. And the other thing is, and I suppose others may disagree, but it's a reflection of the modern society we live in, where people are opting to enter into these relationships, and that they are afforded the same benefits as their marital counterparts.
So can I just ask, do you do a lot of pre-cohabit or cohabitation agreements?
Yes.
Yeah.
In fact, a lot of my practice these days is the front end agreements, and it's a fair mix between those prenuptial agreements and those just wanting to be in a de facto relationship. As I said before, the agreements are essentially the same. The law's exactly the same. You just have to identify what particular part of the legislation applies to the agreement.
That's brilliant. Thank you. And Karen, with your sort of hybrid model, how does that work for you? What are the benefits?
I think aspirationally, it's spot on in terms of what it ought to be doing in terms protecting vulnerable, financially vulnerable cohabitants. I don't think the reality stacks up, to be fair. The powers that the court have are very helpful in terms of property adjustment orders. They're akin to what would happen in a marriage breakdown dealing with either judicial separation or divorce. Similarly, in terms of pension adjustment orders. So once you establish someone is dependent, the orders are very similar in terms of the property adjustment orders that the court can do and pension adjustment orders. The maintenance is dealt with differently because it is identified as compensatory. And I suppose probably one of the big differences, I'm not sure with Australia, but certainly with England and Wales, is that there is provision on death for the surviving cohabitant to make a claim, provided it's made within 6 months And however, the court won't consider an application where the relationship ended 2 years prior to death. So if I was to pinpoint where I can see the development of jurisprudence, it is probably much more visible where you have issues in terms of the estates of deceased cohabitants. And that tends to be quite high profile. It is being reported very well, and the court have very clearly articulated what they believe the provision ought to be, because we have an automatic right under marriage to the surviving spouse. And whilst it's not the same for a cohabitant, there certainly are protections in place.
That's really good. Thank you. Now, Jen, do we have any benefits, and have we got lots to learn?
I was then going to say this was probably the hardest consideration in sort of preparing for today's webinar. I think you really have to put yourself in the shoes of someone who wants to protect themselves, protect their own wealth, and not share, basically, because I think it really comes down to, yeah, there is an absence of rights and protection. I suppose being slightly kinder to the situation, and it's sort of the point that Jeff touched on, is that some would say that there is a benefit to having clear and defined distinctions between the rights of married and unmarried couples. But Ireland are clearly doing that in terms of the extent of the provision. So I think that argument possibly falls short. But I would say anecdotally, it is this idea that you could somehow, if we had reform, that you could somehow be tricked and accidentally fall into a property regime that you didn't intend to. Whereas obviously getting married, you're making a much more conscious choice. And it's this idea that, yeah, in theory, if you don't take any steps, you put clear boundaries in place with your finances, you can, basically protect yourself. But yeah, I'm struggling to formulate that into a coherent or persuasive argument, because I just don't think there really is one.
Although you're a good lawyer and you're doing your very best, if I may say.
I'm trying. Thank you.
So in fact, I think Rory Collett, who's been writing in the chat, is sort of reading our minds, because we're next going to talk about any issues that have arisen because of the law regarding cohabiting couples. And he's raised two questions, and I wondered if we can try and incorporate these. So he says, can we please hear about any flaws in the Australian system? Where does it fall down? It sounds aspirational. Well, we'll deal with that. And also, was startup a problem in Australia? For example, moneyed parties in cohabiting relationships rushing to end before they're caught up in the net of financial obligation. So those are the two-part questions there. So any issues or flaws, and how did it actually get implemented in Australia? But we'll come first of all to you, Jen, in relation to the issues and flaws. You may have articulated some of them already, but anything you want to highlight for us?
Well, I think it's both in terms of the lack of overall legal protection for cohabiting couples and the way in which the relevant law works in practice. As Karen's picked up on, there's a significant link between the way in which the imbalance in our legal system affects those that are more financially vulnerable, and that is still predominantly women. It's no surprise that actually when governments have been talking about reform to the current system, they've usually anchored it on the rights of women and those that are potentially vulnerable to financial abuse. I suppose it's sometimes easiest to look at this as almost a worked example. You know, it's, as you touched on, there's a couple who are in their 50s. They've been in a relationship for 30 years. Their two children are independent, starting off in their first jobs. The man may have worked as a GP. The woman is volunteering at the local primary school. They put the house in the man's sole name because the wife had just given up work when they bought the property after their first child was born. Now, for a married couple, the starting point, probably 50-50 on the house, possibly more if the woman would need it to meet her housing needs. she'd get a share of the man's NHS pension and potentially an income from him to bridge her gap between now and retirement. If they're not married, she potentially gets nothing. She certainly has no way to share in his pension. She certainly has no right to monthly maintenance payments. She's then put in the position of having to scrabble around thinking if there's any financial claims against the property. Perhaps there might have been £20,000 of an inheritance that she invested into an extension at the property. But she's then got to prove that in court, face those cost risks that I mentioned earlier. And you really come back to thinking, well, actually, is that what the couple would have intended to happen? I would say probably the woman didn't. From the man's part, it might depend. And I think there is a real concern that we see on the ground and in practice that there can be a deliberate choice by the financially stronger person in how they arrange their finances, right down to an absolute refusal to get married. They manage their financial affairs in a way that puts in place boundaries, excludes the other person. And then potentially, even when considering if the relationship has broken down, they're potentially waiting until the children have left home, until the children fall beyond the reach of the Schedule 1 provisions, so that their partner doesn't have any claims under that route. And so there is a whole section of society who are in a potentially very financially vulnerable position.
Yes, in fact, I had a case just like that, and we resolved it in mediation. I said to the female cohabitant, the way we need to do this is to go to mediation so that the the male partner will feel so guilty, he'll give you some money because we'll be round a table and he won't want to, say that you can't have anything. And that was the only way we felt that we could resolve it, which is, pretty outrageous in some ways. Anyway, Jeff, can you tell us if there are any flaws and whether that sort of cliff end did occur before the system came into place?
Sure. Just to set the context to answer Rory's concern about flaws, and going back to what I was saying before in terms of the jurisdictional differences between de factos and marriages, in our legislation, we have a definition as to what is a de facto relationship, which typically reflects the common law understanding of it. And our legislation goes so far as to say that a person can exist in one or more relationships. They can be legally married and have at least one, even more de facto relationship at the same time. So they can be very busy. And we've had a couple of instances. There's a reported decision of Green, and then there was the highly salacious reporting about our now deceased billionaire Richard Pratt, the fellows in paper mills, etc., who had a marriage and had two mistresses, and I think a third who piped up on his death in making a claim against his estate. So but our legislation lends to that. In terms of jurisdictional requirements, parties must be an Australian citizen, ordinarily resident in Australia or present in Australia on the day they make an application. I spoke about the requirements in terms of duration. They must be in a relationship for at least 2 years, and that can be a accumulation, a total of different periods. So there must be a total of at least 2 years. So we've had breaks in between. They reconcile, or there's a child, or substantial contribution, or if they've registered their relationship. So we have civil relationship registration provisions under the various states. There is a geographical requirement to be you must be in a state or territory that is what they call a participating jurisdiction under the legislation. And all states and territories are participating jurisdictions except for Western Australia, and I'll talk about that shortly. And the parties must be ordinarily resident in a participating jurisdiction when the relationship breaks down, and that either or both of them must have been ordinarily resident in such a jurisdiction for at least 1/3 of the relationship, or the applicant has made substantial contributions. There's a time limitation. There's statutory limitations that apply to the de facto relationships, and this will become evident when I talk about the issue, that you must bring your application within 2 years following the end of a de facto relationship, although there are provisions for leave out of time. So in terms of the major practical issue that litigants face in Australia, it's really boils down to this. The most critical aspect for litigants in de facto relationship disputes in Australia is establishing the threshold existence or lack of a de facto relationship. They don't have a marriage certificate to fall back on. It's an objective test, a question of fact. Do they meet the criteria? So, and the other thing is establishing when the relationship broke down, because if an application is brought out of time, then you've got that extra hurdle to jump. And there's the real problem for litigants in de facto proceedings is when litigation commences, it's often bifurcated. There's much effort and cost poured into determining the start and finish of the relationship to see that the legislation applies. And often that exceeds the substantive claim at the end of the day. So that's if there is a flaw in the system, it's that. But I don't know how you overcome that because of the difference between the relationships and the objective indicators. As I said to you before, Western Australia is an outlier. They haven't joined the scheme. Their government preferred to establish their own Family Law Act, and that applies to marriages as well as to de facto relationships, but they mirror provisions in the Family Law Act, particularly for marriages. They've done it with the de factos, but not in terms of all issues. So for a long time until this year, parties to a de facto relationship didn't enjoy the benefits of superannuation splitting. That's now being cured by the legislation. The other, and it's a nuanced thing, but more so where you're doing cross-border agreements, you just can't enter into a de facto relationship financial agreement where the parties are offshore. They have to be in Australia at the time. That's a requirement. So it's a bit of a trap for young players and experienced persons who enter into agreements, de facto agreements where the parties are not in Australia at the time. It's automatically not a binding financial agreement. Also, there is a bit of a difference in terms of the ability to apply for property settlement and maintenance. In marriages, the parties can actually apply for property settlement in an intact relationship, and we've had a number of cases where there's been involuntary separation. So for whatever reason, a party isn't living in the matrimonial home because they're in need of residential care, for instance, or they need maintenance. You can only apply for property settlement and maintenance upon the breakdown of the de facto relationship. And apart from that, there's no real issues or concerns. As I said to you before, it's business as usual. In terms of the startup issues, there was a lot of speculation in media about whether there would be a rush at the gate to get things done before the legislation commenced. The problem, of course, was we already had the legislation in the various states. But in most states, there wasn't, for instance, spousal maintenance rights. So where a party was potentially exposed, they try and get their matters dealt with under the state legislation. But apart from that, it didn't really come to fruition as such. So there weren't the problems. But again, I think there's a bit of a difference between the Australian experience and potentially what you might experience, because we had that lead in and existing legislation in place. So it might be a bit more acute and experienced in England and Wales.
Well, I think we'll come to that, but I'm pleased to hear that there are some flaws. That makes me feel happier. And Karen, what about some issues with yours?
Yeah, I think given the restrictiveness, and I think most lawyers would agree, the ambiguity associated with the key eligibility requirements, for example, financial dependence, that has resulted in a lack of litigation. So because of that, we have a lack of precedent and an absence of jurisprudence. And that has been problematic because it hasn't really assisted in the development of the scheme from a jurisdictional perspective. So there is a risk with litigation. It's a gamble. And I think that if you are the financially vulnerable partner in that relationship, you would think long and hard before bringing an application. As I said before, I used the word aspirational. Without doubt, the scheme is right, but what we need is a belt and braces examination of emerging law, investigating how effective the current system is in protecting the financially vulnerable cohabitants, and that hasn't happened, unfortunately. And I know that other countries look to Ireland to say, "Oh, you're doing so well because you're protecting cohabitants." Yes, we are, but we could actually do an awful lot more. There are issues which probably won't be of great relevance to most people who are listening, in terms of taxation and how cohabiting couples are treated. We have a thing called capital acquisition tax, which is attributable to gifts or inheritance. If you're married, there's none. If you are a cohabitant, once it goes over 16,000 euros, you're looking at potentially 33% tax, which is very significant. And then the other would be the dwelling house exemption, where you inherit a property from a deceased partner. It will only be exempt if it was your principal private residence for 3 years prior to the gift or the inheritance. You hold no other property, and you need to remain living in that property for 6 years after the gift or the inheritance. So that is completely at odds to if you were married and you inherit. So I think we've started, but we have more to do.
Well, that leads me very nicely on to my next question, actually. It's as if you read my mind. What are there any plans for reform, and what should the reforms be?
I think that we absolutely need, as I say, the belt and braces examination of how is the system working? What are the cases telling us? Because the figures seem to suggest that the level of application is about 3% in relationship breakdown. So that is very significant in how small a number it is. Certainly, the cases that I've been involved in, they have all resolved. And they have resolved because of the gamble for everyone, because there is no clarity around potential outcomes. There is a very good article by Catherine O'Sullivan, who it's probably the one and only academic article that has tried to get the facts and figures. And what she has said basically is the scheme is an illusion of protection for many vulnerable cohabitants on relationship breakdown. I wouldn't go that far. And I definitely think that there are no plans for reform as it stands, but I do see that there is going to have to be some form of empirical investigation into how the system works, and that is well and truly overdue. And then I'm going to give you a quote. It's Antros is fada, so sail shiv, she lakashkim biog anon. The longest journey in life starts with one small step.
I love that quote. I must learn to speak in your language. That's fantastic. Jeff, any plans for reform? I hope not, because you seem to have it right.
Yeah, not in terms of the de facto side of things. However, our Australian Law Reform Commission did an extensive review of our family law system back in 2019 and delivered a very heady report making 60 recommendations. The government is looking at it, and there's been subsequent reviews of the legislation by other bodies. And I suppose it's a universal theme. Nobody's happy with their system, and it always requires change. But the more things change, the more things stay the same. And we've been subjected to a number of inquiries, even royal commissions into the Family Law Act over the years, and very little does change. But there's movement to try and refine the legislation and make it simpler to understand. There's certainly a sharper focus on domestic and family violence, and a lot of our legislation, our parenting legislation, has been amended, directed towards safety of children and violence issues. Property looks as though it's also going to be reformed in respect of dealing with broadening the claims of litigants, particularly where there is domestic violence and family violence. So that's where the reform's angled at. It's not directed to de facto relational marriages, as I say. They're all under the same umbrella as such.
Okay, thank you. And Jen, what about England and Wales? Do we have any plans for reform?
Hopefully. I think we've managed to shift the debate on from if there should be cohabitation reform to how should the law change. And really, we have got a choice between the two models. We can go for sort of the Australian assimilation model and give couples the same rights, whether they're in a cohabiting or a married relationship. Or we can have reform that looks to keep the two arrangements separate. I think what is going to be key is getting the definition of a cohabiting couple right, looking at how long the relationship has to be. Perhaps what most jurisdictions seem to sort of fit that time frame in between sort of 2 and 5 years. And there's usually an acknowledgement that having children either reduces or completely waives that time period. We had a recent debate up in our Manchester office about the approach that we should take to reform. And although there are differing views in the room as to the model we should follow, what really came out of the debate was that all of the lawyers agreed there on 2 key points: that we've got to give consideration to the children in all of this, and to avoid having a 2-tier system for children of married couples and children of unmarried couples. And the other point was that we need reform which is clear, both in terms of lawyers being able to give advice at the breakdown of a relationship, and for judges if they do have to determine the cases when they go to court. And I think, picking up on your point, Suzanne, about using non-court dispute resolution to resolve these issues, the greater the clarity we have about what the law is and how it might be applied if you went to court, the greater the possibility for non-court resolution, because you can all sit around a table, you can know what the likely or the range of outcomes might be, and you can put that into practice, into an agreement that works for that individual couple. We've got a general election on the horizon, so who knows what the appetite for reform will be. The Conservatives haven't touched on the issue in their manifesto. They previously rejected one of the 2 reports that are fundamental on cohabitation, which I'll come back to. Labour have, under their part of their manifesto dealing with tackling violence against women and girls, have stated that they will strengthen the rights and protections available to women in cohabiting couples. Query what that means. The Lib Dems, again, in their rights and equality section, have committed to extending limited legal rights to cohabiting couples to give them greater protection in the event of separation or bereavement. As things stand, I think we are probably more likely to go down the separate regime for cohabiting couples approach. And that's probably based on the fact that any of our reform is likely to look back to the 2007 Law Commission report on the rights of cohabitees. And that did recommend that a new scheme was introduced. So what are we, 17 years on, and we're still having that debate. And the conclusion of that reform, or that report rather, was to ensure that there would be consideration to the welfare of any dependent children of a cohabiting couple, but would avoid bringing in concepts such as needs. So it would still involve a system looking at what the parties had contributed and what an appropriate separation split would be, but not going as far as marital relationships. And simply for cohabiting couples, there'd be no presumed entitlement to sharing. We've also had the Women Inequalities Commission report. And again, I suppose that actually summarises some of the concerns that we've been talking about today quite succinctly. The report couldn't really have been clearer that the government should reform family law to better protect cohabiting couples and their children from financial hardship in the event of separation. We recommend an opt-out cohabitation scheme as proposed by the Law Commission in its 2007 report. Now, as I say, sadly, the government of the time didn't follow that recommendation, and we're very much in a watch this space territory as to the results of the election on the 4th of July.
Thank you very much. We're going to come on and talk about immigration, but before we do, our wonderful colleague, Jen, Anya, has put some questions in the chat. And this is just a quick fire round. It's just really, really quick, very succinct answers if you would. First of all, how are most disputes between cohabitants resolved in your jurisdiction? Is it court or alternative dispute resolution methods such as mediation and arbitration? So, Karen first, then Jeff, then Jen.
I would say it's a combination, actually. It's generally speaking, it takes the issuing of proceedings to focus minds, and it is generally, in my experience, resolved outside of court by way of negotiation.
Jeff.
We have a different experience. We're told statistically by the courts, only 5% of the cohort of separating couples file applications, so 95% actually settle. We have a very good practice in mediation that tend to resolve matters, and I'd say 70 to 80% of matters resolve with mediation. We've got a burgeoning arbitration practice, and it's a bit hit and miss because we don't have the benefit of dealing with children issues. But yeah, there is a bit of arbitration going on, but not as much as I'd like.
And Jen?
I would say it is generally out of court resolution. I think even for couples where one person is quite firm in the strength of their legal claim, the cost rules and the procedural requirements to look at non-court dispute resolution apply very strongly in these sorts of cases. And as you highlighted, where you've potentially not got such strong foundations to your claim, actually taking it out of the court arena, away from legal principles, potentially gives you a much more realistic and fair way of negotiating a settlement.
Trying to make someone feel guilty, that's what I say.
Yes.
And Karen and Jeff, for you, were there public awareness campaigns in your jurisdictions when the new laws were coming in? Again, very brief, please. Karen.
Yes. That's
Jeff.
me being very brief.
That's good. Jeff.
Apart from salacious media articles, no.
Okay. And for all three of you, are cohabitants aware of the legal principles applying to them before they step into your office? Jen?
No, is the short answer. I think Dr. Google is rife with misinformation and can never apply the law to the specific facts of a specific case. So yes, there's a fundamental misunderstanding a lot of times.
Jeff?
Generally, yes.
Very brief. And Karen?
My comments would echo those of Jen. I think that there is a lot of misunderstanding about what the provisions are. There are some who do, but the vast majority don't.
Okay. And we are just going to slightly shift now to immigration. And I wondered if you could describe the extent to which cohabiting relationships are recognised for immigration purposes, because I think that's actually quite important. So if I'm starting with you, Jen.
Yes, cohabiting relationships are recognised for people applying for entry into the UK. And in fact, actually, since January this year, the immigration rules have even gone further to say that it's not just a couple who have been living together. Actually, there is rights for couples in a relationship, whether or not they've been cohabiting. It has a 2-year time limit on the length of the relationship, so the couple has to have been together for 2 years. But I think what is different and why this probably wouldn't work in the family law arena is that couples are having to submit all of their information and their documentation as part of their application. And that can be a barrier in our line of work. You know, they are going through, tenancy agreements, mortgage statements, all of that information, and it will be a case-by-case decision. But yes, from an immigration angle, we have been able to find a definition of a cohabiting relationship that works in practice.
And what's the situation in Ireland, Karen?
So they have adopted the terminology that the Australians have, and that is cohabiting relations are considered the term de facto relationship, provided you've been in it, it's a genuine relationship, you can demonstrate 2 years of being together, you've lived together, not separately, and you're not related. Then yes, you fit under, there is a criteria there to apply for a permit.
Thank you. And Jeff?
Yeah, very much the same as Ireland, but if you are applying outside of Australia, we've got 309 and 100 partner migrant visas. It applies to both de factos and marital spouses. The definition basically reflects the same definition we have in the Family Law Act. And likewise, if you are applying within Australia, same again. We have both temporary and permanent visas. You must meet the requirements again that reflect the Family Law Act. We don't have a 2-year requirement. You must be in a de facto relationship for at least 12 months immediately before you apply. There are exceptions. For instance, if your de facto partner holds or held a permanent humanitarian visa, that might be exception. And also if you've registered your relationship with an Australian state or territory authority. And that, I know, as a practical measure often happens. So I'm getting clients coming in through the door and there are visa issues. They want to do an agreement, and many of them have actually registered their relationship for that very reason, to get around the visa problems. We also have a number of policy arrangements in relation to domestic and family violence. So in terms of where the relationship breaks down and the person who holds the visa is being sponsored by their partner, the government permits them to remain if you can prove domestic or family violence.
So I now want to try and draw this to a close and to say thank you very much to my panelists. I did say that we would leave a little earlier because it's a gorgeous day out here in England, the beginning of the day. I know it's the end of your day, Jeff, so thank you so much for participating
Pleasure.
late night. Thank you, Karen. Thank you, Jen. Also, thank you very much, Anya, who's behind the scenes, the lawyer helping with all the questions and pulling all the threads together, and also Kira. Anya and Kira, the two associates who really work on our international work and how we put these webinars on and take them forward. Also to the Claire Hobley and the IT department. So thanks to everybody. Really interesting. I feel as though I've learned a lot, and it's given me hope for what we might do in England and Wales, having heard from the other two systems. I'm really grateful to everybody for joining us at this time. Thank you very much. I hope we answered all your questions. I think, Rory, you may have one, but you can stop me at a party and ask me those questions. So thank you very much. And for Jen, Jeff and Karen, we're going to join a Teams separately, and Anya, of course. Thank you to everybody and have a good day.